All right, fam. I'm getting off of work and I'm able to give an update on the Rodney Hinton case as I know of it. So, Rodney had a bond hearing recently, and as you know, or if you could assume, or in your right mind, it was denied, of course. I wasn't expecting him to get a bond or anything like that just because of the severity of the case and who the victim was. So we can go ahead and sum that up to it's going to be what it is. However, we saw less of a police presence in the actual courtroom. This time, the majority of the police that were showing their solidarity and support was in a holdover type observation room along with Rodney's family. And we saw a clear separation between who was actually in the courtroom, which was minimal, to Rodney and whoever the bailiffs was, attorneys, and etc. This makes me this makes me believe that during his arraignment, the presence of the police was not really showing solidarity, but more of intimidation. It supports that it was really there for intimidation because they were all upset at the loss of life at his hands or his actions as a result of, him being upset and angry behind what happened to his son. Which, I'm not in no way supporting or advocating or stating that it was right that he took the actions that he took. However, we're just going to talk about justice and fairness across the board altogether. Anyway, Rodney's brother, don't know his name, but his brother, tried to get his attention from the other side, from the observation room, by tapping on the window just to let him know that, hey, you do have support. Your family's here. Totally get it. I understand. But there is a time and there is a place for everything. He could have stood there. I mean, there's just a time and place for everything. And when you're in court, you know that when you do go to court, it's, very strict. They don't even want you to chew gum in court. They don't want you to look the wrong way in court. They want you to just sit there and observe. And just because you are in the observation room and you're not in the actual courtroom, that doesn't give you the approval or the okay to go just stand up and go tap on the window to get his attention. Although you do want to be there to support your family member. So because he did that, this big commotion started because they were telling him, like, listen, you got to sit down. You can't do that. You can't go up to the window. And here he goes. Once again, you guys, emotions are high. So we have to incorporate all of that. Yes, I do feel like we need to keep our emotions under control and manage our behaviors. But we do need to consider that emotions are high. The family most likely didn't feel like Rodney was being treated fairly altogether, or probably are in fear of these intimidation tactics. Just the day before, you had a slew of police officers that was highly uncalled for. You don't need 30, 40, however many officers that were in there. There was more than 10, more than 15, just to be in the courtroom. To show solidarity, that doesn't make any sense. So, that was that. Like I said, bond was denied. There was a commotion between the police presence, or it wasn't even an issue with the police and the family. It was just the brother being told that he could not go up to the window and tap. he just had to either sit down or leave. But the brother was just so adamant on, I just want to let him know I'm here. I just want to let him know I'm here. You can call him on the phone if he's allowed to have time and let him know that you were there in other ways, that you were there to support him. But that's neither here nor there. It really wasn't too much going on, but we know that Rodney is being represented by the Courtroom firm. The world-renowned Johnny Cochran at his finest, who has now passed, Lord rest his soul. His firm is representing Rodney. So hopefully he will get the best outcome. It seems like they are going for either temporary insanity or insanity, which makes sense. It makes the most logical sense that anybody that has been in that position, some people can handle it, some people can't. Rodney couldn't handle it. He couldn't handle seeing his son lose his life at the hands of an officer on camera as he was running from the police. Now, we don't know all the details. The facts haven't come out yet, or at least I haven't seen them as of yet, considering I'm just getting off for work, but I will be looking into it as far as seeing what the details consisted of with the actual altercation, with the actual chain of events that happened and occurred with the stolen car and him running from the police. Did he point a pistol at the police? What caused the police officer to be in fear of his life to pull the trigger? All of those factors. So I did catch a glimpse, or I did record some of the bond hearing. I think he's got a good representation. I believe that they're gonna do a good job for him because they're already, speaking up.
The time and the history of the accused. So the actual intent at the time of this offense has no bearing upon this court's decision.
I'm not saying that my client didn't try to intend to do this. That's not my position. One more question. You don't know his mindset at the time of the action, do you? Yes or no?
Like I stated previously, with the facts and circumstances surrounding it, and him driving up until that point, and all the circumstances that surround him leaving our office, and from talking to witnesses, he was emotionally distraught, and they were concerned about him driving, and they were concerned about his safety.
No further questions, Judge.
Mr. Bennett, thank you for your questioning. Does the state have any further witnesses?
No further witnesses. No further questions.
Please?
No.
Mr. Bennett, under the statute, the defendant has a right to speak if he wishes at this hearing.
We're not going to exercise that right, Judge. I'm going to speak on behalf of Mr. Hinton.
Thank you, but you do recognize that under the statute that the court must allow the defendant to make a statement at this hearing if he wishes.
That is my understanding, and that's a right I don't wish to exercise on behalf of my client. I don't want him to speak.
Is that right, Mr. Hinton? All right, thank you so much. State have any further witnesses?
No further witnesses, Your Honor.
All right, shall we move to argument?
Yes, Your Honor.
All right, so the position of the state is that, what's the state's position as to bond?
Judge, as to bond, in closing, what I would say is that pursuant to 2937-222, we have shown proof that it is evident that the defendant committed the crime. We have an investigation that includes information from multiple witnesses who are within 1 car length away or less from the defendant, and 2 videos depicting his path of travel, one of which shows the collision. This evidence and testimony suggests that people were worried about him when he left the police department, having just viewed a video of the death of his son. And he was observed by witnesses and video cameras as he operated his vehicle and drove towards where the police officer was. The evidence suggests that he proceeded eastbound on MLK until Deputy Henderson came into his view. The evidence then shows that he deviated from his eastbound course, pulled into the leftmost turn lane and waited. And before he
A fifth third better means an early payday.
Terry, it's coming early.
Okay, I got the bag, I got the key. Who do you want me to call?
It's my pay.
Okay, so yeah, we're having a little trouble back and forth, obviously being there in room A, lots of walls, lots of concrete.
demonstrates prior
Got it back. Let's go
calculation,
back to the
design, and
sidewalk.
premeditation in causing the death of Deputy Henderson, who was a law enforcement officer engaged in the course of his duties. Because of the extremely random nature of this attack, it renders an unpredictability to the defendant that cannot be accounted for with a bond when he was released, because we have no way of preventing him from removing an EMU device, no matter what kind of bond you give him, and gaining access to another vehicle and doing this again. Defendant in his current state is a giant mental health question mark and is a clear and present danger and poses a substantial risk of physical harm to law enforcement officers and to the public, as evidenced by his conduct on the 2nd of May. There are no other alternative means or conditions of release that will adequately protect the public. The weight of the evidence, the nature and circumstances of the offense charged as being an offense of violence, the defendant's mental condition, and the nature and seriousness of his danger to police officers and others in the community strongly suggest that denying bond is both in the interest of the community and in the interest of the defendant. Additionally, Section 2937-222 provides a mechanism in which the Court of Common Pleas can review and modify your order should new evidence come to light if there is a change in circumstances, as that can affect bond. But at this point, Your Honor, we believe that we've read our burden pursuant to 2937-222 and ask that you deny the defendant bail.
What do you have from the state with respect to the personal history or criminal background of the defendant this morning?
Your Honor, the defendant...
And this is required as a review under this statute, Mr. Bennett.
Yes, it is.
Thank you.
So, Your Honor, in 2017, there was a domestic violence charge where the defendant pled guilty of disorderly conduct. In 2019, there was an assault conviction out of Hamilton County. And then I believe there was an assault conviction out of Middletown from 2023 and an aggravated menacing conviction out of Middletown from that same court. So that's his prior history.
Thank you. And what about any known community contacts that you're aware of?
I'm not sure what you mean by that, Your Honor.
His family background, do you know anything about that?
I don't know anything about that, Your Honor.
All right, thank you. Let me turn, have you finished your argument?
Yes, Your Honor.
Let me turn to Mr. Bennett. Mr. Bennett, anything as to bond or bail under the Constitution?
Judge, I'm going to address the factors that are set forth in the statute for no bond and also Criminal Rule 46. Before I do that, in summary, what I would like to do, I want to make certain that this young man is treated as a mentally ill person and not as a cop killer. I don't think he was a cop killer. I think he was not in his right mind. And I think he should be treated like any other mentally ill person that commits a crime under the auspices, control, and authority of a mental defect in a condition. That's what we have in this case.
Do you plan to file a request for a competency evaluation after this hearing?
Yes.
All right.
Yes.
This court is not empowered to do that today.
That's why I was going to ask for it.
If the matter is referred to the grand jury for consideration and further indictment, you may have the opportunity to make the request at that time.
Right. I wasn't making the request at this time.
And I was simply educating the public on the process and letting the public understand what this process is and when certain things can and cannot occur. So the court would not hear a competency referral today.
That's my understanding.
Thank you. Go ahead.
Mr. Hinton's 39 years old. And that you're going to behave in a manner that's specifically safe.
Okay, we're still trying to get back into the courtroom. It's been going in and out, doing our best. A lot has come out over the last few minutes, but right now,
He lives in
I think we have him
Middletown,
back. Let's go back inside the
He lives
courtroom.
in Hamilton County.
All right, okay. All right, I thought
He has lived in
Middletown.
Middletown in the past, but he lives in Hamilton County now.
For how long? Can you share that?
Several years.
All right, go ahead.
Strong family ties. His family retained me. He lives with his significant other and his children. He does have limited contacts with crimes of violence. I think there was several low-level misdemeanors. Other than that, he doesn't have a felonious criminal record and doesn't have a significant history of failure to appear. I think there's one failure to appear. I conducted my investigation, and I couldn't find out where that one failure to appear came from. But what I agree with the state is that there is a giant mental health issue, and I would ask that whatever bond, whether it's a no bond or a monetary bond, I would treated mentally. He's receiving no treatment at Claremont County, mentally or physically. I've got a problem with that. And I would ask the court to take that into consideration with respect to the judgment here or decision on bond. That's all I have at this point.
Thank you. Does the state have anything finally to say?
Judge, the only thing I would say is that I don't really have an objection to him getting mental health treatment in jail. That's fine. I mean, mental health treatment is good. But as far as what we need to show is, number one, the proof is evident or the presumption is great that he committed the offense with which he is charged. We know that because we have video and witnesses who saw it. Number two, he poses a substantial risk of serious physical harm to persons or the public. And he,
Why don't you repeat that first paragraph again that you just read?
the proof is evident or the presumption is great that the accused committed the offense to which he is charged.
Hold it. I will make a finding under revised code section 3927.222 by clear and convincing evidence that the crime was committed as you described based on the information presented this morning. Next.
Next would be that he poses a substantial risk of serious physical harm to any person or to the community.
Mr. Bennett, you want to address that?
I think in light of his mindset at the time that this happened, I was physically present with the defendant over the weekend. I think he has mental issues. I think it's a long way of answering your question. I think the conduct in question is classic mental illness criminal conduct. It's always intentional, it's bold, and it's conspicuous.
I don't know that...
That's a hallmark sign that somebody is not in their right frame of mind, no attempt to deceive, no attempt to hide what they did, because they think that what they're doing is right, and they think that what they're doing is right because they're not in their right frame of mind. They don't understand the wrongfulness of their conduct. So yes, I'm agreeing with Mr.
I cannot recall either in experience or outside experience a case that I've ever seen like this. And based upon the state's comments, I find it very difficult to figure out how there could be any decision based on what they said that would protect the public and the defendant under these circumstances. This is a most unusual case.
I don't disagree with you, Judge, with respect to the no bond.
Thank you so much. I believe that Mr. Bennett said that he agreed with the court with the issue relating. I want to add the mental health treatment. I talked to the officers before. They have assured me, and I'll ask the state to make the assurance that he's continued to be held at Claremont County. To be kept in a safe safe way, and that he will be watched over in a way that would not relate to any self-harm based upon what everybody has said today.
Judge, I don't want to. I don't want the court to misconstrue, or the public for that matter, my comments about his stay in Claremont County. Claremont County is doing a great job. I met with him this weekend. He was in a flat jacket. They're making certain that he doesn't harm himself or anyone else. I just want to make sure, add that component of mental treatment.
You understand that as an impartial jurist deciding these issues between the defendant and his rights and the state and its presentation, that the court's required to make these inquiries?
Yes, Your Honor.
All right. Based upon the officer of testimony, it's Officer Beebe,
Yes, Judge.
and all the facts and circumstances surrounding his testimony this morning, the comments of the state, that there will be an order of remand with no bond. Please assure the safety of the defendant and any mental health treatment that can be granted. No bond, and we'll give, if the officers want to stay, and the public, you're welcome to stay through the other hearings. Otherwise, if you are concerned about this issue, you may leave, and then we'll take just a 5-minute break.
When you're ready.
Some of the bond hearing, I think he's got a good representation. I believe that they're gonna do a good job for him because they're already, speaking up for Rodney's rights. Even though a lot of people may say that he's wrong. Yes, he was, but at the same time, giving some kind of grace to his mental capacity at the time. If they can say a kid goes to shoot up a school, and the first thing that they want to say, oh, well, he had some mental problems, or he has behavioral problems, or he's disabled, or he has bipolar, or he's schizophrenic, or any of these other mental or behavioral diagnoses that you want to say, that applies there. So why will it not apply in this situation where a father became emotionally distraught about seeing his son lose his life? And we don't know what he saw on that tape. Did Ryan point a gun, or was he genuinely running? Yes, Ryan was in the middle of a crime. Whether he stole the car or was with the wrong people in the car, had a gun on him, whatever his actions were, that does not automatically give any kind of reason to take his life, especially if he posed no threat to the officer that made the decision to pull the trigger more than 1 or 2 times. So we'll just have to see how all of this materializes. I know that one of the prosecutors, they did mention that this case, there is a severe, or there's a big, I don't know what the term is or what he used or what he said, but he did basically refer to mental illness. And Rodney's representation, or his attorney, also co-signed that and was happy at the fact that the prosecution did use the term mental illness, because that's what they're going for. That's what they're running with. And it also seems like, they will find it plausible. Now, one thing that got my eye or caught my attention with the defense attorney, and I'm not sure if he was a prosecutor or just a witness, or the officer that took witness statements, but he basically was just calling him out on the witness saying what Rodney's intention was at the time they saw him sitting in his car, lying and waiting to plow through the intersection and unfortunately taking the life of the officer, the innocent officer. No one can tell you what his intention was as a witness, as an observer, which I 100% totally agree with, to kind of like strike that down for you to say, okay, well, I was sitting on the corner of Buffalo and Markham, and I happened to see this guy in his car just sitting there, and I'm going to automatically say, yeah, he intentionally meant to do it. I saw it in his face that that's what he meant to do. You don't know what was going on in his mind. You don't know if that man already has a pre-existing history of mental illness. You don't know if you didn't know what happened and what led him to be at the corner of Buffalo and Markham. So for you as a witness, having no prior knowledge of what exactly is going on or what led up to it, cannot say what someone's intention was to put that claim on them. All you saw is what's happening at this time. So I think he's got a great defense. I think his defense is really going to do what they need to do. It's not going to be to get him off because the whole world knows that it was wrong, what he did. Even though some people may support what he did, but it's never right to take the life of someone else, especially out of anger. So I'm not going to support that, but I'm supporting justice across the board. I want justice for Ryan. If in fact that he didn't point the gun and pose no threat to the officer, he didn't deserve to die. The innocent officer that got hit in the intersection didn't deserve to die. So therefore, Rodney has to pay the consequences for his actions. I totally agree with that. But at this point, it's just, hey, getting the best outcome. If that means life instead of the death penalty, does that mean 20 years instead of life? You know, look at those officers that just got off with murking Tyree Nichols. Now that's what you should be enraged about, because that was on camera. That was innocent. Just because a citizen runs away from the police unarmed, that means that those officers can then beat you near death, causing death, and then get away with it. Are they outraged about that? That's on camera. But here we see, even though Ryan was in the act of committing a crime, I didn't see him point a gun. So maybe that's what the father is enraged about. Maybe that's why he's upset. Because he doesn't want his son to be another victim of, I don't want to call it police brutality, but injustice at the hands of police, and them saying, oh, it's all justified because I was in fear of my life. Not to say that it's right. I'm not saying that it's right, but I understand.